If it please the court, my name is Betsy Sibler. I'm here on behalf of Ms. Laney Mangum. I would like to reserve 5 minutes time at the end of my argument. I'm going to move this down because this is just a little tall for me. So,
if you don't mind standing, yeah.
Is that better?
Yes, thank you.
The case before you today has been up on appeal previously. It was a very complex divorce and custody and alimony case. Ms. Mangum and veterinarian Dr. Larry Mangum were married. He had a very thriving veterinary practice. She is a pharmacist at Walgreens, was at the time, until she left that employment to care for their children. The marriage became irretrievably broken. They divorced, and the Chancery Court of Hamlin County heard that case. It is our position today that the Chancery Court of Hamlin County erred in its original disposition of this case, and then on remand, both erred again in its disposition, as well as did not comply with the mandate from this court. So, with regard to significant property issues, one example of the court's error is in valuing the cattle. When the court heard this on remand, the comment was made by the chancellor that he was going to try to lick this calf again. Okay, you're going to find that the cattle in this property division was a bone of contention. The parties were married in 2011, and in 2013, the parties acquired and began acquiring a herd of Black Angus cattle. The wife, Ms. Mangum, provided the court with spreadsheets showing what they cost. Mr. Mangum did not dispute that those were purchased out of his veterinary practice, which of course provided marital income for the family. He also used that veterinary practice account to pay the family's bills and to sustain his employment. Those cattle were valued at $900 each by the trial court, which is significantly lower than the proof showed that they were valued when they were purchased. And of course, the herd had increased since the purchase time. That's just one example of the trial court inexplicably, to be fair, being unable to actually assign a proper value. It is very important that each marital asset is assigned a proper value because you can't possibly divide it if it's not. Another example is somehow Ms. Mangum's 401k was determined to be exclusively marital property, while Mr. Mangum's 401k was determined to be completely premarital property. Another is the marital residence. The court held that that residence was Mr. Mangum's exclusive premarital property and ignored the deed of trust that Ms. Mangum signed using her credit to refinance that home upon making major remodeling repairs. There is a laundry list. We cannot possibly go through every single one of them in 15 minutes. But those are some glaring examples of errors made by the trial court that are just not explained by the record. Now, while I understand the standard of review is de novo with a presumption of correctness, that is unless the preponderance of the evidence tells us that we can't rely on that. And that's the case here. There are enough of those examples that have been pointed out to this court to seriously call into question how the judge arrived at these decisions. When it comes to the custody of the children, for example, the trial court, once again, said that mother could exercise her parenting time when she wasn't working, but didn't put any such restriction on the father. The father, a lot of the testimony that the court credited for Mr. Mangum was successfully impeached by his federal conviction for structuring tax payments, which is a crime of dishonesty. Ms. Mangum tendered, I'm not going to say all of the proof, but the majority of the evidence as to the value of things, as whether it was the deed of trust, the cost of the cattle, et cetera, et cetera. And Mr. Mangum was somehow taken at his word that certain numbers, facts, and figures were correct without any independent corroborating evidence. Again, with regard to the children, he had his probation changed in the federal courts due to domestic violence against Miss Mangum. He had to take a domestic violence counseling class, and yet that factor was not considered by the properly by the trial court. Even on remand, the trial court looked at that and said, well, everybody's done something in this case, and so I'm just going to discount
What
it.
he said was, if we disagree with him, he went on and said, the court hereby expressly considers the domestic violence of both the parents with respect to their parenting time.
And so, in that case where the trial court says, I expressly considered it, the next sentiment is, and basically blamed everyone for what went on, when in fact, that is not supported by the evidence. The majority of the evidence showed that any kind of outburst by Ms. Mangum was precipitated by Mr. Mangum, okay? And that is,
All right,
is
so
a
make
very
sure I
concerning
understand
thing.
that. You're not so much saying that the trial court just ignored it, that his findings on it go against the preponderance of the evidence.
I am saying that the findings go against the preponderance of the evidence, number one. And number two, there is a statute that doesn't give the court discretion in limiting parenting time for someone who has a credible history of domestic violence. And that federal court conviction provided that. And it is our position that that is but one example from the best interest factors. Another concern with regard to that was the concern shown by one of the expert witnesses, Ms. Nan Buttriff, who stated that Mr. Mangum used corporal punishment with the children, and that was concerning because of his history of domestic violence, where Mrs. Mangum did not. Those are laid out in the brief as well. Overall, Ms. Mangum feels that the marital estate was inexplicably undervalued to the benefit of Mr. Mangum. The items that the court specifically mentioned in its order was not the entirety of the items, and again represented things such as her 401k being a total marital asset when she showed proof that it had a value of about $49,000 before they got married, where Mr. Mangum didn't show similar proof for his, and it was determined to be a premarital asset. Again, Ms. Mangum is still in the position today of being on the deed of trust for that home that was awarded to Mr. Mangum. She can't get another home for herself because it's such a large note. And even with her, professional salary, she's still technically on the hook for that. So it makes no sense whatsoever, legally or otherwise, why that would be considered a premarital residence, that it wasn't transmuted when the marital funds were used to remodel it, when her credit was used to finance the home. And that is quite concerning to her and can't be allowed to stand. So essentially, we're before you asking to once again vacate the trial court's order and direct the trial court to go back through the proof or reopen proof so that those things can be properly established. At this point, we think it would be, advisable for this court to assign a value to certain items because it's in the record. But it does appear that the trial court, while it believed under what it said in its order that he was favoring mom, favoring somebody 60-40 or 55-45 on $400,000 or $500,000 when the actual value should be in the millions. That's not a favor.
Explain to me again why it should be in the millions.
Well, but because the marital property was not counted as, the marital home was not counted as being marital property. That herd of cattle.
But get to the, how does that get?
The herd of cattle.
I want to know what marital property or what property you're saying
The marital residence that was awarded.
And that gets it into the millions?
No, not alone. That's one piece of it. You also have the value of the veterinary practice that produced marital income. You also have the value of a herd of Black Angus cattle that she showed at trial was actually acquired for $3,000 per head on average, some a little higher, and the trial court yet valued them at $900 per head. So you can see where that consistent misclassification and undervaluation is an open question. Those pieces of evidence that you have before you in the record are just not supportive of the trial court's finding.
All right, you have your time for rebuttal. We'll hear from the appellee.
May it please the court, your honors. My name is Cameron Byer. I'm from the Hamlin County Bar, and I represent the appellee, Father Larry Mangum. I was also not the trial counsel in this case. As you know, this matter was previously remanded back to the trial court in April of 2019, giving the trial court instructions to be specific as to the issues of, or the allegations of domestic abuse, the statutory factors that it must consider when crafting the parenting plan, and the rationale behind the property evaluations. It is our position that the trial court did properly apply this court's direction on remand and that the appellant's appeal should be dismissed. We've also raised two issues of our own that were not responded to, and I will address these issues at the end of my argument. In the trial court's written memorandum and order on October 4th of 2019, the court did make specific findings of fact as to each factor it considered in TCA 36-6106. 6 of these factors favored father. 1 of the 15 factors was not applicable, and the rest were an even split between both parents. The court properly concluded that the evidence favors father being the primary residential parent, and the court found additionally as factor number 15 that mother is at times fragile and is barely able to take care of herself and needs help parenting. The court did address the issue of domestic violence and specifically emphasized that it considered the domestic violence of both parents. The court considered both parents victims of domestic violence and ruled that they were equally at fault. The court did not believe that wife was credible. The court concluded that husband's testimony was more credible than wife's, and neither party's parenting time should be limited as a result, as this would have a detrimental effect on the children. Wife's own counselor even testified that the children are on the edge around the mother. That counselor is Nan Buttriff. Most importantly, this issue was first raised upon appeal, on the first appeal. This issue of limiting father's parenting time based upon any allegations of domestic abuse were not contained in any of mother's trial court pleadings. She never stated that father's parenting time should be limited at trial. In fact, she actually testified at trial that she did not want father's parenting time restricted and that father was a good parent. Based upon all of this evidence, the trial court did properly rule that it was in the best interest of the children that parenting time be split equally, 50-50, that neither parent's time should be limited, and that father be the primary residential parent.
Let me ask you, was that announced to the court? What was the the wife asking for? Or what was she suggesting as to father's time?
And at trial, both parties agreed at trial to a 50-50 split. And then upon the first appeal, wife began to argue. In this appeal, wife argues that father's parenting time should be restricted based upon domestic abuse. Moving on to the classification of property, the trial court did properly distinguish between the property that was marital and the property that was separate. This was also done in a fashion that did favor wife by awarding more than 50% of the marital estate to her. The court found that the marital property that was subject to division was both 401ks. Wife's 401k overall a total of $276,000. The increase during the marriage was $127,000. Husband's 401k was also determined to be marital property. His 401k was $43,000. And the court did not believe that it was equitable for any money to change hands, as the property subject to division was essentially a wash, but a bit favorable to wife. The trial court considered all relevant factors in TCA 36-4-121 as to justify why it primarily favored mother in its distribution of the marital estate. It is our position that the court did properly classify the property as marital and separate and divided the marital property equitably, considering the evidence that was presented. There is insufficient evidence in the record to rule otherwise as it relates to the classification of property and to support wife's argument that she should be entitled to any of husband's separate property. Wife presented no evidence of this at trial, and there's no evidence of the same in the record. The real estate, which was the marital home, the court did conclude that wife was entitled to the increase in the value of the marital home. Wife also testified that this was the only property that had increased in value during the home. This property was purchased by husband before the marriage. I'm
sorry, you said the court found the wife was entitled to the increase in the value of the
increase in the value, correct, Your Honor. And the trial court ultimately determined that the increase in the value of the marital home was $100,000.
And awarded that too.
And the trial court awarded the increase in the value to father.
Yes. So the trial court didn't find the mother was entitled to the trial court. You're saying the trial court found that the appreciation was marital property?
Correct.
All right.
Correct.
And then awarded it to husband?
He did. Right. Yes. That's because overall of the marital property, mother's figures ended up being significantly more than husband's figures ended up being overall in all of the marital property. Wife also offered no admissible evidence of any values of the marital home, nor the increase in the value. Husband did hire an appraiser, and the appraiser came and testified. Wife also tried to testify as to the value of the marital home, and husband's counsel did object. He maintained a standing objection to her testimony. Further, wife failed to offer any proof at trial that contradicted any of husband's testimony in regards to his property list with any of the classification of property as marital or non-marital. In regards to the veterinary clinic and the cattle and the farm equipment, the veterinary clinic was never even brought up by wife at trial. Husband was never cross-examined on the value of the veterinary clinic. Wife never claimed any interest in the veterinary clinic at trial, nor the farm equipment. The only evidence that wife offered as to the value of the cattle was what she testified that she came up with online by internet searches, and husband's counsel did object to that being admitted into evidence as well. She presented absolutely no evidence at trial that was admissible as to the value of the cattle. Husband testified that the value of the cattle was $900 a head, And that is ultimately the decision that is ultimately the figure that the court based its decision upon when stating that the marital value of the cattle was $25,000. So overall, the wife was awarded her entire 401k, $259,000 cash in the amount of $3,000, and an adjustment of a Verizon bill minus an adjustment of money that she owed the husband, which was total of $5,885. The total of wife's marital assets was $265,885. Husband was awarded the $100,000 in the marital home increase, his IRA in the total of $43,000, and his business account $15,000, and the cattle $25,000, for a total of $183,000. Finally, I will address the two issues that we raised upon appeal. The trial court ordered on remand that husband shall pay the wife for a Verizon phone bill in the sum of $15,585. This was not proper, as it was not part of proof at the trial. Rather, this was also an issue that was raised by appellant in her first appeal. Finally, this is a frivolous appeal because there is insufficient evidence for the court to do anything but to enforce the judgment of the trial court, and we also ask for attorney's fees on appeal. The trial court properly applied this court's direction on remand, and appellant's appeal should be dismissed. And if there are no further questions, that concludes my argument.
Right here now.
Thank you.
Thank you. We'll hear from the appellant in rebuttal.
I will address the last two issues first. First, about the Verizon bill. It's my understanding that that was part of the debts and assets part of this case when it went through initially. As far as it being a frivolous appeal, we don't feel that this is a frivolous appeal, obviously, or we wouldn't have brought it. There are still questions that I think are fair for this court to review based on its prior ruling, which was you couldn't review what the court had done previously because there wasn't enough information. And we feel like now that it has gone back to the chancellor, and the chancellor has stated in his opinion that he is reaffirming all of his prior decisions and finding this property marital, this property premarital, going down a list, but without reasoning what made it premarital. Why is that a marital property? Those are fair questions. For example, the issue of wife's 401k. She was awarded her 401k. However, the majority of it was considered to be a marital asset. So the chancellor used that to offset and add it to her plus column, if you will, when making the equitable distribution. But Mr. Mangum's was considered to be all premarital. The $100,000 value on the increase of the house. That's not how marital property works. She's entitled to a portion of the actual value of the home. And
if it's marital property.
If it is marital property.
Yeah.
And that's where we believe that the court erred in that specific case, that the deed of trust signed by Ms. Mangum securing the note for that property, even though she didn't write the checks, he wrote them out of the veterinary business, made that marital property. To this day, we cannot take down to Truist Bank and say, well, that's not really marital property. We know that she's on the deed of trust, but don't count it against her credit so she can purchase a home. That has been an ongoing issue for her during the pendency of this appeal. Now, when it comes to what Ms. Beyer had to say about father providing credible testimony, again, we have to bring forward, father was on probation in the federal court for a federal crime of dishonesty, tax evasion, tax structuring. Ms. Mangum did provide at trial, okay, the financial condition listing assets, liabilities, monthly income, and expenses from 2012, which was while that federal case was ongoing, because that was a requirement of the federal court. She did provide spreadsheets of this information. It would be to Mr. Mangum's advantage to understate the value of the cattle, even beyond what they were purchased for, in face of evidence that they were actually valued much higher.
What evidence did you present that they were valued?
The purchase spreadsheets that showed what they were purchased for when they were purchased in 2013, and the financial condition that was submitted by Ms. Mangum. So that's what is, somewhat inexplicable as far as that is concerned.
Or is there any proof presented that the value of cattle that over that period of time from 2013 to the time of trial, it remained the same?
I'm sorry, I did not understand your question.
You said that she presented the proof that here's how much the cattle cost when they
Yes.
were bought in 2013. When was the trial?
The trial was in 2016.
Any proof that the price of cattle remained the same from 2013 to 2016?
There was no competent dispute that the price would not be the same. So as far as did she circle back around, I know that in 2014 there was a marital farm credit balance sheet that was submitted that had all the assets on it, which would include the cattle. But as far as specifically on the date of trial, Mr. Mangum, it's my understanding again, disputed it, and the court gave that credibility, which we don't think he deserved, that they were worth $900. So, any further questions?
I hear none.
Thank you.
Court's thanks to counsel for both sides on this, and enjoy. It's a beautiful day outside, so enjoy your ride back to Judge Frierson's home. Who would please adjourn court to our next regularly scheduled docket?